4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good morning and welcome to the morning session of the Court of Appeals. Your panel this morning will be Judge Armstrong, Judge McGee, and I'm Judge Golden. Mr. Hivner, do we need to address anything before we begin?
I know, Your Honor.
You may call the case.
Richard Mack et al. Versus Cable Equipment Services, Inc.
We'll hear from the appellant.
Yes, Your Honor. This is Larry Parrish. I'll present for the appellant. I will first state that I think I've reread and I've done all I think I need to do to be prepared to argue today. And most of what I want to present to the court is in my briefs, my reply brief and my appellant's brief. I think because this is an appeal from an order dismissing the complaint for failure to state a claim, a 12.026 complaint, and nothing more and nothing less. I would like to focus a bit on what I have put in my brief. They're on page 48. Let's see, I'll start on page 48. And I list all of the reasons that the court gave for why the court dismissed the complaint. And our position is that only one of those reasons is a statement of fact that can be found in the complaint, or the amended complaint, as it were. These are all facts that are stated or opinions or statements of law that are stated that don't have anything that can't be sourced to the complaint. And I want to go through several of those, and they're pretty much in categories. And one of them is the court stated at ROA Volume 5, 198, said the amendment, referring to the amendment of the complaint, in substance raises new causes of action. Well, I would like to direct the court to my reply brief, pages 14 to 17, where there's a discussion of the case of Owens versus University Club of Memphis. And that's an opinion that came out of this court, and it discusses a situation where it's pretty evident there. There was a complaint filed in federal court in 1992, and then it was dismissed, and then it was refiled in state court in 1998. And the question was, did anything occur as far as, was there a new cause of action? And if there was a new cause of action, then the savings statute didn't apply. And in that case, the judge, this court, went through quite an analysis to determine that though there were new people added, though there were new causes of action stated, though that some of the causes of action that were not stated in the original complaint before it was dismissed involuntarily in federal court, that was the same cause of action. So there's about 3 different places here, 4, 5, 6, 7 of the reasons that are given by the court are based on that the amended complaint stated a new cause of action, and therefore the statute limitations had run. And that's not addressed in my appellant's brief, but it is addressed in the reply brief on pages 14 to 17. Another reason that's given is that the torts that are alleged were time barred, and therefore there was no conspiracy. I would argue to the court respectfully that overt acts are not time barred. An act can be alleged in a complaint in furtherance of a conspiracy. You may not be able to get any damages because of it, because that tort itself would not be freestanding, but it still can serve as an overt act. And even though the overt acts are not tied to damages, the overt acts are nonetheless continue to be overt acts. And until the last overt act, the conspiracy is ongoing. and whether an overt act, which is a tort, is a continuing tort, is decidable by evidence and not at the stage of a motion to dismiss. Another reason that's given, quoting what the court said in the order of dismissal, and that's at ROA Volume 5 at page 202, said plaintiffs did not provide these defendants with notice of the lawsuit. And therefore, relation back, the point is that Rule 15.03 was not complied with, and because the plaintiffs did not provide these defendants with notice. Well, number one, I would state there's nowhere in the complaint that says that the plaintiffs did not provide these defendants notice. That cannot be found within the four corners of the complaint. But from
Mr.
some
Parrish,
yes,
well, let me ask you this.
sure.
Where it's a Rule 12 motion and the basis for the dismissal is a statute of limitations. And all of the prior complaints were filed in that same cause or docket number. Is your argument, are you arguing that the trial court, in ruling on that motion to dismiss based on the statute of limitations, can't look at the earlier complaints under that cause and see whether or not certain defendants were named timely or not?
No, I think the fact that the complaint, there was a prior complaint, and what that complaint said is relevant and fair game. But my point is that there's no, I don't understand where there's any statute of limitations issue, because we say, and we argue, and we think we give plenty of discussion in our brief about the fact that the newly named defendants had knowledge. They had co-conspirator knowledge, they had corporate knowledge, they had inquiry knowledge, they had knowledge from the contract. And there are more facts and there are different facts, but it's the same cause of action. And the complaint was refiled within the SOL. It was non-suited, and within the saving statute of limitations, it was refiled. And so there was no statute of limitations problem as far as the refiling is concerned. Then there was an amendment that added the present appellees, and those appellees were added, and the fact that the torts that were named, the torts that were in the original complaint filed in 2011 were timely. There was no statute of limitations problem there. Then there was a non-suit. There was a period of time less than a year. It was refiled, so no statute of limitations ran on those torts. And then it was amended. And then the court had a problem with the relation back. The new defendants that were added in, they didn't have knowledge, so the statute of limitations ran as to them. And so that's the basis for the statute of limitations, I believe. And we claim and do claim now that relation back avoided the running of the statute of limitations on the new defendants that were amended in, because we think we satisfy 1503 and the relation back is appropriate. 1503 says that the added in defendants have received notice, doesn't say from whom, or they knew or should have known, but for a mistake concerning identity, the proper party, they are related back. Now, all of that is a question of fact, and there's nothing in the complaint that says that they did not have knowledge. The complaint explicitly says that they did have knowledge, and our brief discusses the kind of knowledge they had. It's our position that the complaint states facts that would indicate that they had knowledge from the first day the complaint was filed in 2011. and that they were sort of hiding in the shadows and monitoring the progress of the litigation with an expectation that they may be sued. So, and all of those, whether they had the knowledge or they should have had the knowledge, those are questions of fact that I suggest are not appropriate for a court to find in a motion to dismiss proceeding. And then the court finds that the plaintiffs did not demonstrate a misnomer. Well, we suggest it's at this stage and in this context, it's not up to the plaintiffs to demonstrate a misnomer. And there's nothing in the complaint that says that we did not, that the plaintiffs did not demonstrate. And then the knowledge factor continues to be there. There are repeatedly, the court finds the defendants will be unfairly prejudiced to defend the claims which they had no knowledge of. It all gets back to a finding of fact that they had no knowledge. And we, the unfairly prejudiced, we don't even think that unfairly prejudiced is a standard for the dismissal of a complaint. We argued that. And so I have coming up on my time, and I do want to make one point. I have repeatedly said and argued and cited all of the cases that I know to cite about the fact that until a court speaks through its records, the court has not spoken. I've been practicing for 53 years and I keep learning new rules of law. I've learned the new rule of law since I filed this brief. And I think as an officer of the court, I'm obligated to tell you what that new rule, what I have learned and why I don't think that is controls the case here. And I've only got 28 seconds. And so I really don't have time to do that. But there is I'll just mention it. And I got the authorities in front of me. I've already filed another brief on those authorities. And that is the rendered judgment rule. A judgment can be rendered without being in the court's minutes. I don't think that rule applies here, but I'm out of time to explain further.
Let me ask you, Parrish.
I'm sorry. Go ahead.
In the Hamilton versus Cook case, and I'm sure you've looked at it, doesn't
Sure.
it say that it's enough in a non-jury case for the case itself to be submitted to the trial court to block the filing of a voluntary non-suit? It doesn't say that the judge must have already signed the order, but it says the submission to the judge is enough. Do you read that case differently than what I've just expressed?
I read it differently in two respects. That's a bench trial, and this is not a bench trial. This is jury trial. The analogy was made that a motion to dismiss is equivalent to a directed verdict at the end of a bench trial. I don't think that analogy holds up, and I've explained that in my brief. The analogy, do you want me to continue, Alan?
Well, yeah. So you're saying because this submission was on a motion to dismiss, it's different than a submission to decide the case itself. Is that your distinction?
That's true, because you have evidence at a directed verdict level. The court has heard the evidence in a bench trial or a jury trial, either one. And so here at the motion to dismiss level, there's no evidence that's been presented. All of the evidence is in the complaint, and all the evidence is in the complaint has to be analyzed on a Conley Ladd web basis, so that all the facts that are alleged are facts. There's not any room to dispute about them, and not only that, they have to be interpreted in the way most unfavorable to the non-movement, and unpled acts have to be assumed in order to say, is there any way that this plaintiff can prove a cause of action, whether it's stated specifically or not in the complaint? So we think there's a big difference because a motion, a directed judgment motion, comes after evidence has been heard by the court.
Okay, thank you.
Any other
You're-
questions? Thank you. You'll have your rebuttal, Mr. Parrish. We'll hear from the appellee.
Thank you.
My name is Bradley Eskins. I'm representing the appellee. I think it's first important to note that all of this stems from an incident that occurred on August 29th, 2010, 11 years ago, following the retrieval of or attempted retrieval of a cable box. We're now 11 years post that incident. There was a lawsuit filed in 2011. And following that lawsuit, it was non-suited and dismissed in 2014. It's not until 2017, some 6 years after the initial incident, that our clients were named in a lawsuit. There is an attempt by the appellants to assert that the 2017 allegation relates back to the 2014 complaint, which then in turn relates back to the 2011 complaint. And it's simply a bridge too far. One of the points that was made by the court concerning Rule 1503 and was an additional issue that I had not heard discussed in oral argument from the appellant, but it also says that within 120 days after commencement of the action, the party to be brought by the amendment receives such notice of the institution of the action. There's no allegation that they served or provided any type of formal notice in the amended complaint, or whether it be 2011 amended complaint or the 2014 complaint or the 2017 complaint. That they provided notice. Simply put, the statute is long since run on this complaint. In fact, the allegations that are asserted fail on the relation back for another point, and that is that the amended complaint asserted 20 pages of additional allegations of conspiracy and 8 new defendants. And I will point the court to its own opinion on this very case, Mack v. Comcast Corporation, which was decided in 2018 by this court, 2018 Westlaw 419-1878 at page 2. The court makes specific note in that case that the amended complaint added an additional 20 pages of allegations and 8 new defendants. There is nothing in the subsequent complaints or the pleading that explains or justifies how these 8 new defendants and this conspiracy claim and an additional 20 pages of allegations somehow are the same complaint or the same causes of action that arise in the initial complaint. In fact, in looking at the complaint, it adds allegations of conspiracy and asserts that the conspiracy is ongoing, presumably to avoid any statute of limitations argument. But there's no doubt, and it's in the record, that Cable Equipment Services, who I represent, ceased doing business in 2015. And this amended complaint in 2017 is simply 7 years after the alleged incident and 2 years after we ceased operations, is simply a bridge too far on any kind of statute of limitations argument. The procedural history of this case is tortured, to say the least, as far as the numerous amendment complaints and dismissals. But I will also point the court to something that was stated by the trial court, and that is, in addition to prejudice, and another complaint would be futile. The plaintiff has already relied upon the saving statute once in amending their complaint and filing it again, and now presumably are seeking to amend or avoid the non-suit the issue and refile again on that non-suit issue, and then assert to do it again. Hunt v. Shaw, 946 Southwest 2nd 306, recognizes long-held principle in the law in Tennessee, and that is, after the taking of any non-suit to the original action, any additional suits would have to be filed within the 1 year of the first non-suit within the purview of Tennessee Code Annotated 28-1-105. So allowing, it was what the trial court pointed out, was allowing the defendants to voluntarily dismiss their case yet a second time and then try to refile again would lead to the same result. And the court pointed out the statute of limitations is still run. The saving statute would not help the plaintiffs yet a second time, and it would result in prejudice. There's been some discussion about this Hamilton case, and the Hamilton case was cited and is actually relied upon by a reported opinion, or at least discussed in a reported opinion. And in that case, the court very plainly set forth that where there would be prejudice would occur where the defendant has demonstrated a valid statute of limitations defense, which we have, and the defendant or the plaintiff sought a dismissal after participating in a hearing where the trial judge expresses an adverse opinion on the merits of the plaintiff's claim. Well, that certainly occurred here. There's no doubt that the court announced the ruling, was waiting on an order, and the defendant, or the plaintiff, I'm sorry, the appellant, waited 2 months to attempt to non-suit or dismiss the case when the court had already issued a ruling and was trying to get an order entered on the issue. That's squarely within the purview of Hamilton v. Cook. And the facts of Hamilton are strikingly similar to this case. But I would argue that the facts in this case are stronger than even Hamilton when one is looking at the statute of limitations argument, because it's a double layer. It's not only the fact that they're trying to non-suit, but the statute of limitations, nearly 7 years after the incident was filed, to attempt to relate it back is simply a bridge too far. I would also point out to the court that there's been no plain or set forth argument as to in either the appellant's brief or the reply brief as to how they avoid the statute of limitations. It's clear that the statute of limitations is present, and the court has set forth the standard for a frivolous appeal, and I would assert that asserting this appeal at this stage, based on this procedural history, is a frivolous appeal. It's taken for delay or to avoid the final ruling on this, and it's devoid of any merit and has no chance of succeeding. Even if
you raised that as an issue in your brief?
I did, Your Honor. Page 30 of my appellant brief, I asserted that the appeal in this case is frivolous, and we've sought attorney's fees for a frivolous appeal.
Did you raise it as an issue?
As an issue. We did not appeal, but we've in our response to their brief, we raised it and sought attorney's fees in our response. In our response on our brief, after receiving their issues presented and their brief, we requested as an issue that this was a frivolous appeal. And
well, that's my question. Did you raise it as an issue?
Yes, Your Honor.
It's an issue stated in your brief?
Okay, so it's not an issue presented before the court, no, Your Honor, but it was a request in the brief itself.
All right.
But the court,
you didn't file a counter appeal on that issue on that issue and raise that as an issue?
Because there was no issue at the trial court, because we didn't ask for attorney's fees at the trial court, we're asking for attorney's fees for the appeal.
I understand, and that's what I'm asking you. Did you file a counter appeal and raise that as an issue in your brief?
I didn't file a counter of appeal, no. I just requested it in our brief as well. But I will say that even under the standards, the court can assert that on its own. Tennessee Code Annotated 27-122 asserts that the court can award fees for a meritless appeal as well. And we're asking that, based upon the pleadings and the evidence presented and the clear statute of limitations, that the court recognize that the appeal was frivolous and devoid of any merit, and to award attorney's fees.
All right.
I mean, my brief lays out the procedural history. There's no point in for me to belabor the issues as far as the timeline is concerned. I simply state that there's just no way they get around the statute of limitations argument, and it was readily apparent to the trial court. It's readily apparent in the procedural history that was filed. It's readily apparent in the record that was filed with this court, as referenced in our brief. And based upon that, we assert that the appeal should be denied and that we should be awarded attorney's fees. And I'll cede the rest of my time.
Thank you. Mr. Parrish, you have 3 minutes on rebuttal.
Thank you, Your Honor. Because the statute of limitations is argued here so much, I think it's necessary for me to go back and rehearse the statute of limitations issues. The complaint was timely filed in 2011. In 2014, it was non-suited properly. The complaint was refiled within the SOL within the 1 year after it was originally non-suited. It has not, and since that time, the case has been prosecuted and has been on appeal. There hasn't been a break after that time. Now, the non-suit on 2 of the defendants, not on a third of the defendants, the third defendant, but that non-suit was taken not by motion, as was the case, as I recall, in Hamilton and the subsequent case that followed Hamilton. There was a motion to non-suit. Here, the non-suit was not a subject of motion. The non-suit was noticed, and it was properly noticed, and it was properly noticed and with respect to all of the law pertaining to non-suit, voluntary non-suit. And the statute of limitations has not started to run on the refiling of that non-suit. And those non-suits were to 2 defendants who had never been non-suited before. No order was ever entered, although it was asked to be entered, and the court referred to the order and knew they had to enter an order. Until that order is entered, the statute of limitations does not even begin to run. What the court attempted to do was say, I'm not recognizing the non-suit. Well, there's nothing to recognize or not recognize. It is a fact. It's there. It was filed 100% in compliance with all the rules concerning that. There's nothing in this complaint that his client, CES, ceased doing business. It's just said they ceased doing business. The court said that. There's not fact one in this complaint that can be sourced to establish that that's the fact. And so we don't see any statute of limitations problem here. The fact that there's 7 years that has elapsed, that's unfortunate, but it's not legally significant here. Nothing happened in those 7 years that caused the lapse of any statute of limitations. We think our authorities in our briefing established that to be the case. The 120 days, saying that we had not established 120 days, you don't do that in a complaint. That's not where a complaint, the office of a complaint. Thank you, Your Honors.
Thank you. Thank you, gentlemen. We'll take your case under advisement and issue a written opinion as soon as possible.
Thank you.
Mr. Hibner, please adjourn court till this afternoon's docket.
This honorable court is now in recess until 1 p.m.